My lord, I beg to mention, my lord, item number 32, my lord.
Yes.
Yes, in this case, my lord, what is happened? Actually, my lord, we filed this bail application, my lord, before registration of the case, my lord, FIR, my lord. Thereafter, my lord, I have already filed, my lord, AB, my lord. That AB is, my lord, 1878. So, my lord, I am not pressing this IA, this bail application, my lord. Item 32.
32.
Yes, my lord.
And the AP. Okay,
May I please look? May I please look? May I please? I beg to mention item 25, Lordship. In this case, I incur from the learned PP. In this case, charge is submitted, Lordship. Additional interim, Lordship.
Direction submitted, my lord. Charge sheet number 198/24. 198/24 dated 306/24.
Petitioner or interim, Lordship. Direction may be given to approach the learned court below or regular bail till that interim may continue, Lordship.
10 days it will be done.
Much of
Well, I filed an IA for correction of a court's order. It was passed on Monday. Interim has been granted. My lord, instead of my lord Helem PS, it is mentioned as Bishwanath PS. My lord. Can it be a 2, my lord? No, less.
Sir, I beg to mention item number 23 for withdrawal, Lordship. We have instruction to withdraw. 23,
Your instructions to withdraw.
Lordship.
CD.
Otherwise, we have received the CD.
Yes, ma'am.
I have instructions, Lordship.
You are MSP Bora?
P. Borua.
P Bora. Instruction for it.
24.
Oh no, sorry. Withdraw and withdraw. Hold on. CDP return. CDP.
Your ladyship had heard this matter at length on Tuesday last.
Yes.
I wanted to file a written argument subject to what your ladyship said.
Please, your lordship, with the consent of the other party, I beg to mention item 28. My sir is not well.
28.
Yes, lordship. His absence of the intimation is also there in the cost list. Can it be fixed on Friday, 2nd of August,
Who
lordship?
is the senior?
Ditul Das, lordship. Yes.
For the informant.
This is for
For the informant.
informant.
Yes.
Lordship, interim protection may be continued and on Friday it may be fixed. Over phone he requested for consent.
2nd of August.
And for the petitioner.
Second of
But that's also for the respondents that's informed for an adjournment sitting there. And I will get for an adjournment, but at the strong it is we received the case record. CD. CD received. It is instead of the case. So it can be Friday. 2nd of August. 2nd of August is a Friday. Friday list should be a bit less. We have some
Thursday.
next Thursday.
Thursday.
What
1st of August, Lordship.
1st of August.
it is there?
Hearing day.
Okay, it is 1st of August.
Obliged, lordship.
Yeah, please, your lordship. My prayer is for item number 38. Lordship, can this item
30.
38?
38.
It is listed for order.
Ah.
Can this matter be taken some other day? Lordship, consent is taken from the other side. And also I am praying for listing of this IA along with another IA criminal number 541. Similar case, Lordship.
IA
IA criminal 541 stroke 2023.
Please, your Lordship.
So here you are for the petitioner.
In the IA, I am for the respondent.
No. For in a criminal appeal, you are for the appellant or
I am for the accused.
Lordship, I am for the appellant.
you are for the appellant?
Yes.
So he is seeking an adjournment.
Yes, Lordship. Lordship, kindly give a short date, Lordship, for the matter.
Why the 23 matters? Is there any the accused is behind the bar?
Yes, Lordship.
It will be listed after 2 weeks.
2 weeks.
2 weeks. Interim, oh sorry, it's not taken. Okay. And IA criminal 541-23 will be listed together.
May I please, Your Lordship?
After 2 weeks, criminal IA 541 listed along with this.
May I please, Your Lordship? I wish to mention for listing a regular bail application earlier rejected by Your Lordship. Maybe on Tuesday, regular bail application.
31.
Maybe, Lordship. I will mention item number 45, Lordship.
40.
45, Lordship. Supplementary, Lordship. So, as for office note, Lordship, scan copy of case not been received, Lordship. For reminder, maybe issued and fixed,
Not yet received.
Lordship.
Body of this not being scanned. PhD accordingly. Yes, any date you want to fix?
Can copy मतलब otherwise BA मतलब
Yes,
commercial
because it is a BA, that's why.
commercial quantity BA after 2 weeks.
That's one
Want any fixed date or after 2 weeks?
8 of August, Lordship.
8 of days.
8 of August.
Lordship, date may be fixed, Lordship.
It will be on 16/8. 16/8.
16 August.
Yes, 16 of
May I please, Lordship? I beg to mention item number 42 is mechanically taken up with item number 37, Lordship.
44.
42.
42 with
Kindly taken up with item number 37.
37. Okay.
When 37 will be called.
Yes.
Lordship, I wish to mention listing of a left-out matter, Lordship, on 29th. I wish to mention listing of a left-out matter, Lordship.
Not possible, Ben.
Lordship, on 29th or 30th, Lordship.
Left. It will be on first week of August only, because it's the whole is full, in fact.
1st August, Lordship. Okay.
May I please, Your Lordship?
Huh? 5th of August. Yes.
May I please, Your Lordship? Lordship, item number 16, Lordship. Is there was call forward? Item 16. 16.
16,000.
1/6.
Lordship.
Yes, madam. Should be not fixed.
Lordship, interim was there, Lordship.
You are needed.
Lordship.
Did you remember?
13 of August.
13th of August. 1/3.
1 3.
May I please, Your Lordship? I'd like to mention item number 41, Lordship. 41. It's a hearing matter, Lordship. NCR has already been received. However, the service is yet to be completed upon respondent number 2.
Respondent number 2.
Yes. New matter, Lordship. I am already on bail. Lordship, may kindly take this matter after 4 weeks or after 6 weeks at any date.
Mr. Hardward, 41. Mr. Hardward, that of the hard Mr. Big Impression, Latex, he have been this one. For office, the scan copy of the SJ is complete. Reminder. Huh? Oh, sorry, sir. LC is already done. However, it's a bit corresponding. You want any fixed date after 4 weeks or
After 4 weeks, Lordship.
this time?
Alright.
May I please, Your Lordship? I beg to mention my item 30, Your Lordship.
30?
Item 30.
Should be not fixed.
Ma'am, I pray for adjournment of the matter, Your Lordship, due to the medical emergency of the engaged conducting counsel.
Anyway, you are on interim here?
Yes, ma'am.
Subsequently, receive the CD receive, madam.
CD received. And the request by the interim counsel. Yes. You are appearing on behalf of Mr. S.A. Hussain?
Yes, ma'am.
S.A. Hussain. Adjournment is free. The health issues he is not to appeal. However, CD is matter accordingly. When the CD
5th of August.
5th of August. CD matter accordingly on 5th of August. CD be retained till 5th of August. CD interim.
Yeah, because I beg to mention item number 36. But in this case, CD is not listed.
CD is not listed.
Are you on it?
36, no.
You are not.
Not in interim. It's POXO.
POXO.
Notice.
Notice, I have taken steps for it.
On 6th of August.
No, service is still awaited or we don't know. 36.
36.
You have not taken any step.
I have taken none.
You have HT has not received any step from you.
I have taken steps not to for the PP.
How? In which manner you have taken step?
Directly given to our office.
I have taken steps for PP lot.
So you have to submit before the registry because of the.
That's why there is a note of registry that they have not.
And
Then malat it may be called after some malat on regular time. We'll
Yes.
enquire in the office. Then
okay.
That's no answer.
May I please, Your Lordship? Lordship, page number 39, Lordship, the earlier rejection order, Lordship. But there was a direction to the learned trial court, Lordship, to dispose of the matter within a period of 6 months, Lordship. But till 10 months has already left, Lordship, there is no any progress in the case, Lordship. That's why second admission was filed.
While taking the matter, almost 6 numbers of witnesses were already examined.
Yes, sir, out of 7, Lordship.
Yes, that's what.
Scan later, see like the scan copy, what is the material against him.
It is a case of from this Kamur Petro? Or?
Yes, Amingaon.
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 Second week of August? Or 19?
119.
119. Yes. Hello.
Me, please, Your Lordship. My Lord, diary may be called for, my Lord, NDPS in between.
Your petitioner is in custody since when?
My Lord, 22 days, my Lord. Can it be on 13th or 14th of August, my Lord?
13, 10.
13, 14, পুলিশ বিল অফিস থেকে 15 আগস্ট
না সময়টা দেখুন হয়
on 9th I'll try.
9th will be too early, man.
Then will not
13th.
no 13th একইটা
আচ্ছা।
পুলিশ বিল
Oh.
law and order কিছু না করতে my lord on 16
I'm obliged, sir.
Your Lordship,
Yes.
that case for yesterday also came, that Supari, that 2 person came, Your Lordship, I remember page 13, Your Lordship, kindly see, father and the brother, my lord, they are not directly involved. One the allegation is that Sabur has sold the land in connivance with others, my lord.
You are also a seller.
No. I am the father of Shafiqul, my son, my lord, that deals with the business.
Or you are the father.
Father and brother, younger brother of Shafiqul, my lord. Now we are looking for 42 days, my lord, custody, my lord. Neither 4 or 6 comes, nor 379 comes, my lord. My prayer is, my lord, at this stage, without calling CD, my lord, Your Lordship, make on subject to what my lord and friend says, my lord. Your Lord, can you see the FIR, my lord? There is nothing against them, except one word, my lord. That is the Sobus sold it, my lord, in connivance with others. And Sobus said they lordship yesterday granted bail saying that Zimma was not given to him, my lord. Supari remains in the particular place, my lord. So my father, he is a teacher, my 56 years old, my lord. And
Can you tell us the number of yesterday's number?
yes, yesterday Shafik is 1869. Shafik's number, my lord.
A18?
1869. No, AB.
Oh, it was AB.
AB, that was AB, my in time your lordship granted. In time. Shafuk's phone number is there? 1900. Yesterday is 1900.
Lokipur PS case number 164 2015. Lokipur PS case number 164.
Lokipur case 164.
Already yesterday's matter earlier there was.
Case that is called 21st August, man. 21st August. But here, madam, by that time there will be certificate will be over. Man. Here, further custody is my only fear. One line photo, okay? 1 line. 1900.
Thus, are you appearing for the other cases also?
No,
Other case, one case, Mr.
Bhattakur appeared.
Mr. Bhaskar Somay appeared. Bhattakur is here, man.
Education intermediate disability.
Yes.
Super 250 days. Okay.
Hey, that's super.
Lokipur case.
I mean, allegation of theft are not against them.
Yes.
It was recovered and someone volunteered to keep custody of it so.
Right.
And thereafter the owner of the super people he sold along with some others to,
Right.
Yes. during the investigation without any intimation to the officer in charge.
Yes.
Or the IO. That is the case.
Yes.
Can understand.
Father and mother 42 days already custody.
They are father and mother.
Father and mother, madam, they are not at all involved, madam.
Mr. Motilkar was the order. The item 8. Interim was there.
Order to look at my
Order to continue.
Okay, will be granted bail.
CGM Golpa.
To the satisfaction of CGM Golpar.
CGM Golpa.
We have the copy with you. This earlier order is there. Or you can take a copy of it.
Dispose of mirror?
Yes, dispose.
Mother will give a copy of yesterday's order. I will give.
Can.
Yes.
Madam, since it is disposed of at the motion says one line objection may be recorded.
Yes. 1 line, 2 line also now. Yeah, nothing, madam.
Objection was there from the, in fact, from the side of Bhattakur that they sold the supari without any intimation to the officer. It is not the allegation of theft against these persons. The supari was seized, I think, by police. And it was taken Jimma by one of the students, but without intimation they sold this one. That is the one is the owner of the case, and others these two are the father and most probably father of the owner of the supari.
Exactly. Obliged to. But a copy I will give to him. Yeah.
42 days custody.
Sign over to apply.
Next item 4. CD may be called by the NDPS, my lord. Oh, sorry, madam. So, my lord. Notice will have to go to that here, madam.
Yes. That's cool.
Mayang, my Morigao district, madam. Nearest to go to
Harendra Biswas will be informed.
Informant. Father of the victim, madam.
Call for Is it a case with a charge sheeted one or
Madam,
is it a case with charge sheeted?
Scan copy of that, madam.
2 witnesses already examined.
2 witnesses already.
Scan copy of POXO case number 1 of 24. Pending in the court on a special judge Morigao.
Special judge Morigao.
Morigao. Date, my lord, your worship is what is the
Also issued. Notice says there are some confusion in issuing notice. Somehow what they're doing directly to the office of the
PP, my lord, to OC, officer in charge notice to serve.
No, there's other forum also. To the registry will do, I think. Huh?
Yes, ma'am. The registry also done.
From registry, PP will actually. It will be go through OC, doing the police station, routed to the office of the registry and the public prosecutor. So what has happened in some cases, there is a note of the registry that they have not received any step from this way. So that is the reason. So this is the matter. Through registry, then they will send to the PP's office. PP will accordingly.
Madam, alternative justice service also may be given, madam. We may also, let us try, madam, in languishing in the custody, madam.
Let the notice be served, usual notice as well as through PP's office, both ways.
Both sides. Okay, no. That will
Yes,
do.
can be given, that can be.
My lord, on 22nd of August.
My lordship, this is already 53 days in jail, my lordship. NDPS Act. So I'm seeking bail on the length of detention, my lordship. In other similarly situated cases, my lordship, in 43 days also.
Yes, anything to you got arrested in connection with this case on 3/6.
Yes, my lord. 53 days, my lord. Below commercial quantity.
This is from Jalukbari PS, my lord. Let a short date be given, my lord.
From Jalukbari.
Jalukbari, my lord.
He is already 53.
Because at this stage I do not know, he may be a habitual offender also.
No,
these things.
no criminal interest.
I have all right, but these things will come in the case there only, my lord.
My lord,
So it is difficult to consider.
Order of the session court may be seen, my lord.
Address Tuesday, Tuesday. Next week Tuesday. Today or Friday? Because the statutory period is over. But you are released. It can be
33-0, my lord.
30. You try. And also you take an instruction if FSL is, whether FSL is collected or not, or whether the investigation is already over. That kind of information you can take.
My lord,
Otherwise, he is in 53 days custody. 30.
Highly obliged.
Please, the regular bail, election of 21 bail or NDPS lordship. It's behind the bar 21 days, 15 days lordship. And here is the lordship, the main accused is Jiten Vishwas, and petitioner is the wife of the Jiten Vishwas from the house.
Wife for engaging.
My lord, yes, from Lakshmipur district.
Lakshmipur.
Let it be 16, my lord. 16, 18.
May it please you, Lordship. I am for item number 7. This is a bail application. This case is related to NDPS and intermediate quantity. It is about 17.8 gram of heroin. Lordship, we are behind the bar from last 14 days. Lordship, at this stage, CD may be called.
Yes, Judge, CD can be called.
On same date, no? 16.
16 inch.
Thank you. Obliged.
please, Your Lordship. Lordship, it's a 439 application. FIR is in page number 9. Allegation against me, Lordship, under 120B, 420, 406 and 379 PC. Lordship, as per the FIR, I extorted some money from some passengers of railway. Here, nobody filed FIR against me. Only railway police filed FIR, only on suspicion base. Lordship, they told me that I took some money fraudulently from some passengers through online mode and some cash on account of providing some tickets. RPF personnel against me. Lordship, this is the third application before this court. Earlier, Honorable CGM and Honorable Sessions has rejected my bail application, and today is the 45th day behind the bar. Lordship, the length of detention shall be considered, and some grounds may be considered, Lordship, because FIR did not lodge by any victims. Also, no material proof found during the investigation. Only police in the city, they told that I confessed before the police that I took some money from the passengers. Confession before the police, it's not admitted, Lordship. So my humble submission is that, considering the length of detention, my bail application may be considered, Lordship. My Lord, as it appears from the FIR itself, he was identified on the basis of CCTV footage. And he is a habitual offender, my Lord. Because again he came to commit such type of offense. Not let the case there come.
Yes, because CCTV footage also he was recognized, seen.
Yes, yes.
And some passengers also recognized. So he
Yes.
was doing this thing.
Doing this, my Lord, habitual offender.
Seems to.
As it appears from the cause, my Lord, FIR itself.
Right.
So let the city come, my Lord.
Were also rejected. So let us case there be Perus.
Lordship, one short date, please.
Short date.
On 8th of August. 8th of August. 8th.
8th of August.
नहीं बोल रहा हूँ लोगों पर किंतु नाहिले आपको डेट को लंबा कर रखना पड़े नाहिले आपको डेट देखिए ना तो तुम्हारा टाइम बढ़ी जाए हाई लेवल
Yeah, please, Your Lordship. Lordship, both the petitioners are behind the bar since 29/6/24. Today is 28, His Lordship. Allegations under section 406, 420, 468 and 471 of IPC, Lordship. Lordship, Siddhi may be called for.
There are two petitioners. Two petitioners are there.
Yes, Lordship.
So she is behind the bar, most probably they are behind the bar for 28 days.
Yes,
27 days.
27. So when can
मतलब पुनः उम्रान सुनिए है ना on 12th of August
12th of August.
May I please, Your Lordship? It's regular bail, Lordship. CT may be required, Lordship. CT may be called, Lordship.
The case of NDPS.
Lordship, offense under section 331, clause 4 and 305, clause A of BNS Act, Lordship. The FIR in page number 9, Lordship.
305A is
5A,
for
Lordship.
earlier, IPS, what is the section?
It's 380, Lordship.
380.
And 331 for it's 457, Lordship.
We are calling for the case diary. Yes.
case there will be recorded
Yes, when can it be?
on 16th of August
16th of August is too late, a short date maybe given that.
Yes, that can be any short.
I can try, but whether because 15 August is coming, police personnel will be busy with law and order situation this time.
9th August, Lordship.
I will try, my lord.
Much obliged.
May it please your lordship.
Yes.
My lord, 483, my lord, paper application, my lord. Here, my lord, allegation is that petitioners were playing cards, my lord. There behind the bars, my lord. If lordship peruses the order of the learned session, that it will be clear, my lordship, that they were playing cards only.
Is that page?
Page 30, my lord, the rejection order, page 30, paragraph 5, it will be clear. Page 30, that they were playing cards. And some packets of cards. Perusal of the CD shows that accused persons were playing cards by betting with money, this is spelling wrong, my lord, placed in center and playing cards, your lord. Yes, my lord, further custody may not be required, my lord. They were playing cards.
Simply playing cards, or is there any other?
No, card is again. Order to listen, card.
Otherwise, what is in the FIR? FIR is at page?
FIR at page 10.
17.
Page 10, your lordship, but the ordered lordship, it reflects that they were playing cards only. From the CD also it reflects. From the page 30 is the gist of the CD. It reflects that they were playing cards. Page 30.
Garius is closer.
Seized items? What are the seized items?
My lord.
Seizure list, have you annexed seizure list?
Bedsheet and two vehicles.
Huh?
As it appears from the FIR, my lord, two vehicles were also seized. And my lord, one bedsheet, white bedsheet was also seized.
On any condition, they have learned sufficient lesson, my lord. Possibly they will not play again cards. They are behind the bar.
Other those, what do you call this? Some items are also there using all these things.
But
These are not there.
No, they are all cards.
Yes, playing cards only. And my lord, that is rejection order is passed after examining the case diary.
Page 30.
Case diary was produced there.
Page 30, it is reflects, my lord, page paragraph 5, that only cards were found from the case diary itself.
Money were paid.
Money
were there. And why you are in the night of 10:30 and 45 you were engaged in playing cards? Why?
Lordship, they were playing cards, your lordship.
No, why they were playing cards in the night?
They have learned.
Is there any other explanation from your side? That's what I'm asking.
Oh, my lord, further custody may not be required, your lordship, because they were playing cards only. There was no betting, nothing, your lordship. They were playing cards. And cards recovered, everything seized, my lord. And there is nothing for the investigating agency to investigate also, your lordship.
Okay, let's Mr. SM here. SM Abdullah B. is an approximate police officer, not listener connection with it is submitted by Mr. Abdullah that the accused petitioner they only playing card by sitting in the room of the guest house. At that apart, they have not committed any other offense as well as CDF. From the directed order of the United Trial Court, also it is that CD also Lanet code below. On Lanet code below, it reveals that from the CD. No. That Lanet code will of the reveals that on page of the case diary also, it was seen that they were paying cards by the accused petitioners. That about some of the articles, some articles and they are behind the bar since 13/7/2000 and further can further interview and be required for the investigation. After that, that they were supposed to be playing cards, but as per the allegation, as per the statement made in the FIR, there are some allegations brought against the petitioner. However, the of the FIR said that except it's only seized one set of gambling play card, some amount of money, some Android mobiles, and vehicle from the possession of the accused petitioner along with one white page. Consequently, the article also the Mr. will record your objection or I have recorded.
Simple objection. I pray that CD may be called.
Okay. So and so, however, Mr. He does the be submitted for the requested to call for the case diary. Considering so meticulously length of detention on the other nature of the offence, I find that custodial interrogation of the further custodial. Spare cases?
CGM Kamru Metro.
CGM Kamru. CGM. Okay, all will be released with 20,000 with one security to the satisfaction of CGM Kamru.
I'm deeply obliged, Your Lord.
May it please your lordship. Pre-arrest bail application, my lord. My lord will find at page 11, my lord. I have not been named in FIR. FIR registered under section 379, my lord. Page 11, your lordship. It was lodged on 31st of May, your lordship. At the top, your lordship will see. And it is respectfully stated here that since last few days, so-and-so company have been working on the electric line at so-and-so under APDs. On last so-and-so, we worked till evening. But on 28/5/2024, FIR was lodged on 31st. We could not work due to weather condition. On so-and-so around 1 p.m., the accused persons named below by bringing so-and-so, number so-and-so, along with goods carrier magic vehicle number so-and-so, stole 2 drums of aluminium wire. This is the allegation, my lord. And I have not been named in the accused person. But, my lord, since I am dealing with scrap business, my lord, police is without issuing 41A notice also, my lord. 379 it was registered. I will go, my lord, I will record my statement. But, my lord, so at this stage, and it is 2 months ago the FIR was registered, my lord, 31st of May. And allegation was on 28th. And I have not been named in FIR since I am dealing with scrap business. So this is the doubt, my lord. So I will go and record my statement, but without issuing notice, my lord, police is searching.
My lord, let the case diary come, public property, my lord, stolen like this.
Searching him because he is the scrap dealer. That's why it's searching him, because probability of selling all those items in his shop cannot be denied at this.
My lord.
And
He call for otherwise.
my CD maybe until then, my lord, I will go and record my statement, my lord. That protection, my lord. Because, my lord,
because in this scrap business has been a lot of. My lord, I have come across one case. 2 city buses was taken away in the broad daylight with the help of crane, and it was vanished within a day.
in Bihar, my
In
lord,
a scrap.
one bridge
This-
was taken away by
These things are going on. So my
one
lord
breeze,
knows.
big breeze.
My lord, let the case study come.
My lord, otherwise, my lord,
The case deal will come.
my lord,
Because
then my lord,
with
protect,
the-
I will go and my 379, my lord.
No, 379 is okay.
My
But
lord.
the question is we call for the case diary, because
By that-
time what is there, maybe recovery also.
In fact, my lower court, while rejecting my bail application, has that your lordship will see page 17, suspicion, suspected, last paragraph. The CD contains some material suggesting that accused person purchased the stolen article. Are not recovered, my lord. Police, such was operation was conducted by police, not recovered. I will participate in the proceeding. I want to participate. I have not a 2 months back incident, my lord. Till then, your lordship protect me. I will go. I will record my statement. I will participate in the proceeding, my lord.
My lord, 2 months
Till the-
time is, my lord, enough to make disappear the stolen properties.
My London friend knows everything. In
But
Bihar,
city
one
buses
news was
being
there,
picked
my
up,
lord. One,
I surprised to come across that case.
or here, my lord, aluminium wire, my lord. This is not big bridge or truck like my London friend has said. Let my lord CD may be called for. If material is there, your lordship may reject my bail application, my lord.
That's why you do it and also but that's the application and sections will it is received or both. It is subject to Mr. Goyal and accountable. He has not committed such offense as well as in the FIR. He is not an FIR named accused, and accused persons who have already committed the offense are declared by police. However, could have been searched for the present petitioner as he is a scrap dealer, and but that he is not served any notice under section 41A CRPC. However, he is waiting and cooperative IO for the granted privilege of NDPS. Mr. Das, Dealer PP, submitted that being scrap dealer, his involvement cannot be denied, and the city will be acting back on the Mr. Goyal submitted according that from the rejection order of the first by the London Trial Court below. Also, it's that CD, as per the materials of the city, there was a suspicion that the present petitioner might have purchased the stolen articles. But as 2 months has already been lapsed, the police immediately proved there is a progress of the and this fair begins. Okay, it will be under interim protection. It will be for
On 27th of August.
Deeply obliged.
My Procedural same. This application under section 482 new act for pre-arrest bail to the petitioner. Page 11 is the FIR. It's a short FIR. May I read it?
yes.
Respectfully begs to state that at Khagarpur Nitto Bazar near 31 NH, I have a shop. At the said shop on last night by breaking wall, stolen away some goods worth about 2 lakhs. This is the FIR, Lordship.
I am not FIR accused. Now, why and how my apprehension is come, that's I am going to explain, Lordship. Please peruse the forwarding report, Lordship. Page 16. May I read? During investigation, CCTV footage has been collected nearby shop of PO, and reliable sources has been engaged to find out or identify the culprits. On dated 14/7/27 at around 11 p.m., information received that some miscreant with a vehicle were roaming entire Bongaigaon district. As per direction of SP, Bongaigaon Naka checking was conducted at PS area. Accordingly, OC Jogigopa PS staff signaled one vehicle in front of PS checking point, but seeing the police personnel, 4 persons who coming in a vehicle bearing registration number so and so left the vehicle and trying to run away, but police persons caught them and taken Jogigopa PS with vehicle. During examination, all persons confessed that on dated 12/7/24 at night they criminally entered into one shop at Khagarpur near NH 17 by breaking the wall and looted huge amount of copper and bars utensil and sold to one person named Amir Khan of Borpeta. During search of vehicles, some stolen articles has been recovered and duly seized. Accordingly, DYSP Bongaigaon and SI Bir Singh Bordoloi, along with apprehended persons named Mohibul, Mia and Saidul Islam, and staff left for Borpeta. On dated 14/7/24 at morning, on being identified by apprehended persons, another person named Amir Khan, son of Tosher Khan, village Bhatkusi, PSL district Borpeta, has been apprehended at Howli market. During interrogation, Amir Khan confessed that on dated 13/7/24 at early morning, he received 3 bags made of copper and brass utensil from the 4 persons who were already apprehended. Amir Khan also informed that he sold that said article to one Roham Ali of Koyagusi. I am Roham Ali, my lord. 4 accused persons stolen the stolen articles and they have sold to the Amir Khan. Amir Khan was a scrap agent and Amir Khan sold to me. I am the scrap dealer. Lordship, I have not purchased the stolen article directly from the theft, from one agent. Lordship, page 18, please see. This is my trade license. I am the scrap shop owner. And page 19, one order I have annexed. And in this order, it's reflected that the all stolen articles are already recovered. Now, my lord, offence registered under section 313(4) and 305A, New Act. Paragraph 10, my lord, please see. My petition, I have mentioned section what says. Page 6, paragraph 10. 331, clause 4 says, whoever commits lurking, house trespass or house breaking after sunset and before sunrise in order to the committing of any offence punishable with imprisonment shall be punished with imprisonment of either description or a term which may extend to 5 years and shall also liable to fine. And if the offence intended to committed theft, the term of the imprisonment may be extended to 14 years. 305A says, whoever commits theft in any building, tent or vessel used as a human dwelling or used for the custody of property shall be punished with imprisonment 7 years. Now, Lordship, according to this FIR, I have not committed theft directly from the shop of the complainant. I have purchased that articles from one Amir Khan who has been purchased that article from the actual theft. These two sections, Lordship, not attracted against me. Lordship, CD may be called for. In the meantime, interim protection may be given to me. I will cooperate the investigation of the Lordship. Because direct allegation not against me, Lordship.
Or again, against scrap dealer.
Scrap dealer. That is.
I have objection to Milord interim order.
Lordship,
CD may be called for Milord.
But this case is different from earlier case, Lordship. I am not purchased directly from the theft. And being a scrap dealer, I have to deal with the business of sale purchase of scrap material, all kinds like iron, plastic, etc., etc. And
your business is to these are stolen from shop. So these are new items.
No.
New utensils. He has no business to purchase all these things.
That will be.
He can purchase only scrap materials.
Yes, yes. But
broken materials.
But thefts are after
So,
stolen.
I have objection to that. Intent.
But after stolen, the thefts are they make it scrap type. Not in new condition. Not that they are supposed to sell to another.
Let the CD come.
Interim protection level.
There is short date be given.
Interim protection level.
On 8th of August.
On earlier one, Lordship, that is more than serious to this case. That was Lordship granted Lordship. So I am not.
Serious and serious no. That was the case wherein it was allegation or it was suspicion that he may purchase.
Lordship.
There too you have directly purchased.
Yeah, I have purchased not from the directly theft, my lord.
Those.
They are in the other case. With the other case.
Lordship. I'm for, in any condition. I.
In a sense, in that case, it was a suspicion.
Yes, my lord.
He might have purchased.
In any.
There too you have purchased only. That's what.
I mean, those materials were, the other case, the materials were lying on the site of the contract.
All on you.
Here, Milord, shop was break open, Milord, and then it was stolen.
But if I registered under.
After appraisal of the case, that your custody detention may not be required. That we are not saying on that. But at present, most probably, it will not be safe to call for that. Because from the forwarding report I have submitted, it is a direct evidence against you that you have purchased.
Yes.
In the earlier one, there was not any. It was a suspicion, but here too you have purchased.
But
all we are trying to give you
whatever maybe, Lordship, the FIR was registered under these two sections, Lordship. Whether these two sections affected against me or not, Lordship. These two sections, Lordship, affected against me or not.
That will be looked into after appraisal of the case.
Interim protection I am paying for, Lordship.
On 9th of August.
Where would you or because you are not will be in the interim, that's why your interim will be not considered, so you'll be 9th of August. You are 5th, 6th. 5th or 6th carried.
5th will be too early, I think. Look. 7.
7th of August.
Because tomorrow and the day after tomorrow is holiday. Only Monday will have our message go through.
Message will go on. Let it be on then.
Not on any condition. I am paying for condition. 6th. I will cooperate the investigation officer also.
Let us see.
Any condition kindly consider interim protection, my lord.
6-8.
6-8. Most of us.
Lordship, in this case, we are supposed to file an affidavit, Lordship. The affidavit is ready but could not be served. I will be filing it today, Lordship. We may fix any date after 10 days.
After 2 weeks. Come after 2 weeks.
You are for respondent number 2.
Lordship. Respondent number 2. Respondent number 2. For the inform.
So you have already filed the affidavit in opposition, or you are going to file?
Now another affidavit necessary because of some subsequent development. One, I want to bring one communication from the Director of Health Service, which suppose that the birth certificate is fake. That document I want to bring to the notice of the court, Lord.
You are Mr. F.K. Singh?
Your Lordship,
Mr. F.K. Singh?
I am assisting him, Your Lordship. Senior Counsel. I am Mr. V. Pushilal, Your Lordship.
Okay. Hard Mr. V. Pushilal, that counsel for around the hard Mr. Counsel respond number 2. It is submitted by Mr. that there are some subsequent development, and on the basis of which the respondent want to file an affidavit. according to date number 9. Prayer allowed. Let the matter be accordingly listed. After 2 weeks, it will be listed.
Not sure fix it because that is interim order. Please continue.
Order was there.
No.
Plus, fix it after 15 plus any date.
15th of August. After 22/8. So 22/8. And by that time, you just file here. And
Yeah, last, there is an interim order.
And I believe the respondent number 2 to file his verification.
22/8.
The last interim may continue.
Interim may continue.
I am for response number 1.
Yes, state response number 1. Okay.
My lord, for our convenience, a short written argument prepared, 2 page only.
But in this case, my lord, as per office note, my lord, dated 22/7/24. Earlier, while order dated 17/7/24, up to date status report was called for. But that up to date status report is not received, my lord. It was sent only on 22nd of July via email, but it is not received, my lord. I have checked, my lord, office note.
Not to have it so short date, I think. Huh?
Because of the short date, my lord, only because it is, my lord, after signing, it will go to the section.
Your lordship had this matter on the last occasion, and whether,
Yes,
and my information concerned, my lord, nothing updated, my lord. This I have mentioned in my written argument. No PW is examined, even after 1 year have been elapsed.
Total 11 witnesses, out of 11 witnesses, 3 examined. 3, no?
3 examined.
So as per the last entry, when the next date is fixed?
Next date, my lord, my file is not there. I have to check, my file is not there. I have just last date to speak.
No.
Last,
Yes.
yes. Here last order of 21 February 24, it was fixed on 12/4/24 for evidence. From 21 of January, February it is not up to date. Because of that, up to date.
So up to February
21st February 24 last order, it was fixed on 12th of April for further evidence.
12th of April.
Yes.
So up to 21st of February, 3 witnesses were examined. So after that, case date will be. Or you can submit one thing, you can do one thing. If you had that information, you can take out the status report of the case from the website or from the website of the office. That can be done. Otherwise, we have to fix it, because if suppose 21 to 2024, 3 witnesses were examined, from 24 it was fixed on 12/4. Even after 12/4 also, 3.5 months had already been done. So considering this aspect, the status report is required, but here too we do not have a status report. Yes,
Commercial quantity case,
my lord, matter may be fixed on 30th, 30, and in the meantime, my lord, on that date, I will furnish the fresh orders, my lord, from 12/4 to 20.
It has to come from Kamruk Metro?
No, my lord, Karimganj.
Karimganj.
I will furnish, my lord. I will furnish on 12/4 to till date, my lord. Orders date
Now,
to furnish.
yes, obviously, furnishing thing will do. Definitely.
My lord, may fix 5th or 6th.
But the question is, what effort the learned court has taken, that will not come in your that status. That is one of the biggest problems.
It's better, my lord, may fix on 6th. In the meantime, it will come.
Or, my lord, as the record called for. So I think, my lord, it may be sent, may not be tagged with this record.
No.
Or, my lord,
Latest note of office note dated 22nd of 7. It was sent via email. Only sent.
so come with the email also, my lord, scanned copy. So it's not time is required. So on 30th, my lord, record will.
30th may not be possible.
They has to prepare the status report, then to send. It's not like that email send and report come. They have to prepare a report.
The entire record has to come under the scan copy.
Madam, I can section 6. Sometime in
Then why in the office note it is reflected on 24/7 that the updated scan copy of the case record has not been received? So it was not received in fact.
not received. Not received.
Let it be on fifth or sixth. Otherwise it won't come. That February it has to be picked on either fifth or sixth. Let it be
6th, madam.
sixth.
6th of
Office note reflect workshop report. So dated 24/7/2024. Repeated that the scan copy of the updated website not received. Mr. Parash had done it with the earlier record. Under the earlier from the scan copy of the earlier record, it seems that the last LP was of 21/2024 and the date of fixing was 12/4/2024 for further evidence. Hence, he submitted that the status of the case along with the updated scan copy will be required. Was not raised it accordingly directed. Call for the is accordingly directed to issue reminded to call the scan copy of the updated case record. Matter will be listed on 6th. You are saying 6th. Your note will keeping your note here. 6/8.
public.
Yes.
Lordship, in this case, earlier medical report was called for.
Yes, medical report received, my lord. It's a my lord.
Lordship, in this case, two witness examined. They are the Caesar witness, possession not confirmed. Lordship, kindly have a look at the Caesar witness, deposition of the Caesar witness.
But total 7 witnesses. Fact is that
Possession not confirmed, Lordship.
this case is
These
of
two persons,
2019.
the Caesar witness, Lordship, kindly have a look.
Charge sheet filed on 31st of May 2020. But this petitioner, Igor's petitioner is a habitual offender, my lord. He was earlier arrested in a case of Mizoram.
Two cases again lost against him. One at Silchar, another at Lordship Mizoram. In the first case, he was released on bail. In the Mizoram case also, he was released on bail. What happened during the period while he was in custody in Mizoram case, warrant was issued. In case of Silchar case, Lordship. That's why he was once again arrested. Otherwise, in both the cases, he was released on bail. Lordship, kindly have a look at earlier bail order. One at Lordship, kindly have a look at page annexure 3, page Lordship 18. 16 Lordship. Page 16, annexure 3. He was released on bail in the Silchar case Lordship on 17/3/2020. Lordship, accordingly, accused Rajan Pradhan alias such and such is allowed to go on bail of rupees 30,000 with 2 sureties. He was released in first case during the Lordship period of investigation. Lordship, again kindly have a look at annexure 6, page 25 to 27. He was also again released in the Mizoram case also. It started from page 25 and operative portion of the order is page 27. I have heard both parties. I have perused the case record. I received a letter from such and such who is currently detained at District Jail Champai, was referred out at District Hospital Champai due to right flank pain, unable to eat and excessive weight loss for 4 times. On further investigation by the medical officer, the said UTP was referred to Medicine Department, Civil Hospital, Aital, or said UTP further in management. Also seen medical certificate referring the accused to Aital Civil Hospital. In such a situation, The accused Radhen Pradhan is released on interim bail for a period of 5 months. So in both the cases, during the period of investigation, he was released.
I could not follow you. Actually, what had happened? Release on bail will come later on, but the question is that here in this case, when he was arrested,
In this case,
yes,
Your Lordship, that is kindly have a look at.
7/11/19.
It is on 11/3/24.
11/24.
he was arrested on 11/3/24
Lordship,
in connection with this case.
in this case, as he was unable to appear in the court, court issued warrant, and on the basis of the warrant, he was arrested.
In Silchar PS, earlier he was
Released, but he released. He appeared in the court initially, but subsequently failed due to as he was arrested in Aizol case. That's why he was unable to appear in the court proceeding twice or thrice. At that period, he was once again honorable court issued Lordship a warrant of arrest. On the strength of warrant of arrest, he was again arrested in this case, Silchar case. Silchar case, at first he was released. Again, he was arrested on the strength of warrant, Lordship, as he failed to appear in the court proceeding.
Earlier bail order কোন কেসে ছিল? Earlier bail order কোনটো কেসে ছিল?
Exactly, page 16. Page 16. So, Lordship, I am ready to appear before the court, Lordship, and he is suffering, Lordship. That's why I am pressing, Lordship. And their Caesar also not confirmed. In this case, there is a rare chances of conviction, Lordship. Both the Caesar witness stated that
where is the earlier order?
Earlier order?
Earlier order of bail.
Bail, Lordship, page 16, Annexure 3. Lordship, got.
When he was granted with bail, in that time period, was a charge sheeted case or no?
That time charge sheet was not submitted. Lordship, yes, that time charge sheet was not submitted.
CB colon decision. Page 16 on Procedural case. But it was granted only because of his ailment.
Ailment, Lordship. That's why. On special condition, he was granted. Mizoram case also on special condition, bail was granted. Now he is also suffering. Lordship, he will appear with any condition, any further condition, may be released. He will appear, Lordship.
Now, my lord, when my lord is granted, bail was granted page 16, 17/3/22. The court court doesn't know that he is involved in any other case. Yes, at that point of time, only in Silchar case, he was granted bail because of his ailment.
Again in the Mizoram case, when page 24, then also, my lord, there is no record before the court that he is involved in another sincere case.
That is true. But in the case,
No,
Lordship,
let me submit. Let me. First bail was granted on 17/3/22 because of the ailment. There is no record before the court that he is involved in other case also.
Because of his ailment or his parents' ailment?
No, he
Yes,
submitted. Parents. Mother have been suffering from various ailments. Mother. Now, in page 25, when he was this bail granted on 22nd of February 24, then also there is no record to show that he is involved in any other case. That is not before the Lanet Court below. Now, my lord, at the present stage, my lord, it is clear that he is involved in at least 2 case NDPS commercial indemnity both. And now, my lord, that embargo of section 37 will definitely come, my lord, that yes, medical emergency is another thing, but section 37, that he is a habitual in both the cases involving commercial quantity. In one of the case, my lord, I'll give the copy, my lord. Meghalaya High Court allowed a person the bail granted as because he is HIV positive. But Honorable Supreme Court, by observing all this, that section 37 embargo will come, that bail was also rejected. Now, in the record, my lord, yes, medical record has come, my lord. He SLP criminal 16021/23, SLP criminal 16021 2023, State of Meghalaya versus I'll give them a name is difficult. Copy. It's dated 16/7/24. Letter. It's HIV positive person, but Supreme Court rejected. Now here, my lord, in the record, my lord, yes, medical report is there. Jailer given report that he needs to be surgery. So my lord may direct why bail is required. He may be surgery may be done in GMCH. For that, my lord, bail is not required.
Lordship,
if my lord, report in the health report is there, it is written that surgery is required. It can be, my lord may direct the jail authority to arrange, and he can be appointed in the GMCH, in a higher hospital. Since they have no facility. Charge sheet submitted on 31st of May 2020.
31st of May
2020. Earlier he was arrested on 7/11/19. Earlier he was arrested in 7/11/19, but subsequently bail granted on 17/3/2020, and subsequently 31st of May 2020. But again, as he is not
and
appeared.
you were arrested in Mizoram case when?
Lordship, it is on 11/3/2024.
No, Mizoram case.
Yes, 11/3.
11/3/24.
In Silchar case, Lordship.
No,
Mizoram case. Mizoram, Lordship, it is from the.
In the present case, again he is arrested in 11/3/24.
That is it.
Lordship.
You were arrested on 16/10/2020.
So 16/10.
That means from about 3.5 years he was absconding.
No, Lordship, he appeared before the court.
Oh, yes.
While yes, Lordship, kindly have a look at page 23 on learned code below.
23.
Lordship. Second para, Lordship, third para, Lordship. From the perusal of the case record of NDPS case number 28 of 2020, it appears that the accused was granted bail by the learned special judge on such and such, and his bail bond was accepted on 18/3/2020, and thereafter he was appearing, not expounding, Lordship. He was appearing. Record further reveals that thereafter the accused remained absent. Only after while arrest of the Mizoram case, he was absent. And his bailer appeared before this court and submitted that they are unable to produce the accused as he was arrested in connection with another case. So, Lordship, if he is also again, Lordship is taken into custody, he cannot appear before the Aijol case, Lordship. So that case also could not be proceeded. Another aspect, Lordship, section 37 will not come, Lordship. Two witnesses examined, both the witness, Lordship, kindly have a look at these two are the Caesar witness, and Caesar was not confirmed. If Caesar was not confirmed, Lordship, there is a rare chance of conviction. In that event, Lordship, section 37 will not come. So my humble submission, Lordship, in both the cases, he will appear with any other condition, Lordship, if he committed any further act of such act, Lordship, then in that event his bail may be cancelled. At this stage, Lordship, he may be released, so that he can appear before both the court, Lordship, in the proceeding of both the case.
In the earlier occasion, my lord, his bail was granted because of mother's illness. Subsequent in the Mizoram case, his illness. And now, my lord, that judgment, Supreme Court judgment, para 10, my lord, kindly. Page 5. The subject FIR, so 21C 29 NDPS Act would reveal that the quantity of the contraband involved is 1.040 kg of heroin. The impine order granting bail of accused on 20 would be revealed. This time also the bail was granted on the ground that she is suffering from HIV and conspiracy without adhering to the mandate that section 37, even after taking note of the fact that the rigor of section 37 NDPS Act call for consideration in view of the involvement of the commercial quantity of the contraband substances. When the accused is involved in offence under section 21C 29 of NDPS Act, more than one occasion, here also more than one occasion, my lord, and when the quantity of the contraband substance is heroin, 1.04 kg, much above the commercial quantity, then non-consideration of the provisions of the section 37 NDPS Act has to be taken as a very serious lapses in cases of like nature of cases discussed. Bhavani Singh, this case is discussed, my lord, would not only go against the spirit of the said decision, but also would give a wrong message to the society that being a patient of such a disease is a license to indulge in such serious offences with impunity. In the situation, it is to be noted that this case, Bhavani Singh case offence involved was not one under NDPS Act. We have no hesitation to say that in the above circumstances it can only be held that the twin condition of the section 37 NDPS are not satisfied, and on the sole reason that the accused is HIV positive cannot be a reason to enlarge her on bail, since the impune order was passed without the adhering to the said provision and in view of the rigor standard of the accused is not entitled to be released on bail, the impune order interferes. So, my lord, it's here, my lord, yes, you have referred to surgery. Surgery can be done in GMC also. And earlier he was granted for the mother illness, subsequently his illness, and he is involved in both the case commercial quantity. And earlier occasion, there is no knowledge of the learned court below that he is involved in other case. Now situation is different.
Lordship, kindly have a look at
One more.
another order of
How many numbers of
Seven witnesses.
Two witnesses, I
Two witnesses.
Other party witnesses are yet.
Because, yes.
But these two are Caesar witness, Lordship.
Delay caused by him because of he was not present. He is
in this case, or there are other experts?
no other sole.
Oh, so
Sole. Because my lord, he was subsequently arrested only on 11/3/24. Subsequent to 11/3, two witness examined.
and these two witnesses are vital, Lordship. See, they are Caesar witness, Caesar not confirmed. So section 37 will not come in this case. In my case, section 37 will not come, and I have even an order of our High Court, Lordship, kindly have a look at. In that case also, he was suffering, and this Honorable High Court released the accused petitioner on bail. Lordship, kindly have a look. So if Lordship, if he remain in custody, Lordship, there will be delay in Ijol case, Lordship. One case he can appear, another case he will remain in absent, Lordship. Both the case he will appear, Lordship. And he is suffering both the condition, Lordship, kindly have a look at and order passed by our High Court, Lordship. In another case, in that case also, petitioner was suffering. Lordship, kindly. And my lord, my humble submission, section 37 in this case will not attract, as they failed, prosecution miserably failed to confirm the possession. Both the two witnesses are Caesar witness. If Caesar Lordship possession not confirmed, in this case there are rare chances of conviction, Lordship. So this is my humble submission. All right.
My lord, I am sorry, my lord. I appeared again, my lord. I pursued the record room, my lord. In item 13, my lord, record received yesterday. The record received from still, sir. So matter may fixed on 30th, my lord, 30 with records.
If received now, then
Received, I have just
it is
pursued.
fixed on 6/8.
Or maybe 30, my lord.
No, say 3.
3. Obliged.
Not 3. They are not fixed.
Both, my lord. Still, my lord, scan copy not received.
May I please allow? Perfect, as per office note, this can be on CD not received, my lord.
And
The service of, my lord, the number is completed, my lord. As per office
For a
note.
number 2.
My lord.
POXO 6.
2 is completed. Na?
The LCM.
If in spite of service they have not appeared, whether do you want to say that amicus could be or could not? Okay? No, amicus be open.
Amicus may be, my lord, because till the answer come, my lord.
But Mr.
M. Hock.
M. Hock, that not. also heard Mr. K.K. Prat that we are paying from the office of that state says the service is already completed. Not number. That's information. No one has behalf of it for number 2, and hence I find it proper to and appoint one MI prosecutor on behalf of to appear on behalf of the respondent. Mr. Karnam Pradeep to also is accordingly hereby appointed to the MI as now was maybe appointed as on behalf of the STP in intimating the MI prosecutor. Further, office note that the scan copy of DLC is not yet to remind the STP. List accordingly when it can be fetched. After 2 weeks, do you give a date?
That is still.
That will they still wait, but we are fixed because it's a bailment.
Yes, sir.
19?
1908.
1908.
Ma'am, what is it? 53 days, like a town on the control.
Yes.
May I please, Your Lordship?
Did you receive?
Yes. It's an intermediate quantity, Lordship. Recovery was 2 kg, 450 grams, Lordship. Ganja. Joint possession of 2 person, Lordship. 1 and 2. And they are 52 days on and as on date, Lordship. 52 days. And the third person, Lordship, he was arrested on 17/6, Lordship. That 40 days as on date, but no recovery from him, Lordship. He was arrested later on in this case, Lordship. No recovery was there. Considering the length of detention to 2 kg, 450 grams of ganja, Lordship, 52 days, Lordship. And Lordship consider local person of Guwahati itself, Lordship. And rest, I leave it on Lordship.
Lordship, only the FSL report is awaited. Otherwise, Lordship, the petition number 1 and 3, Lordship, they appear to be 1 and 3, Lordship. They appear to be consumer of drugs, Lordship.
1 and 2.
1 and 3.
1 and 3.
3 and 2 appears to be a Lordship. He used to engage in selling of ganja, Lordship, in and around that area. Petitioner number 2.
Petitioner number 2 engaged this both 1 and 3.
1 and 3, Lordship, appears to be they used to buy ganja from petitioner number 2.
Honest, Lordship, not big seller, Lordship. There is small, Lordship, that small Urias like, Lordship, that Lordship, ganja, Lordship, already 52 days, Lordship. Local person, Lordship, that is the main person. Phase 2, Lordship, will see the forwarding report also. They are from Guwahati itself. Any condition.
Lordship, Shuttle Gate, Lordship, Maligaon flyover, near that railway flyover, Lordship. We also know, Lordship, that these things are bought and sold of there, Lordship. Shuttle Gate area, Lordship.
They used to sit in footpath and all, Lordship.
It was still in Puria line.
Yes, Lord.
German all persons are and their done, they will go to the IO for it. Next draft done it. The quantity recovered, you will get amount 20
Lordship,
2 kg.
2 kg 450 gram.
recovered is 450 grams, which is much lesser than the commercial quantity. Mr. Rama, that his diary is within the details number 1 and 3. Not only business, but they are also consumer of the ganja, and the prescription number 2 deals with the business of ganja. However, he submitted that till date, I will not collect the FSL report in spite of several days of a though it has already been sent for FSL for example. That was the submission made that it was for material separation with his diary. Another aspect that I allowed all the accused persons to go on bail for rupees 20,000 a month tag not 30,000 which once you tag registration of. Here it is special just Kamur Metro.
Kamru Metro.
Okay, well,
Lordship have made that clear, Lordship, that 1 and 2, Lordship, 52 days, and petitioner number 3 is 40 days, Lordship. Date of arrest.
42 now.
Lordship?
52 have I have already
Lordship.
40 days.
40 days.
Number 3.
Number 3. Otherwise it will go bad mess. Much obliged, Lord. Much obliged. Much obliged.
18 Lordship, CD has not been received.
18. CD not received.
18 received.
My lord, my lord, only 2 times my lord CD was called for. My lord, lordship may peruse the page, my lord, as I have page, my lord, page 7, my lord. What happened, my lord? Both the girl and accused person and eloped, my lord, both are not in the marriageable age. The petitioner is aged about 19 years and the girl is aged about, my lord, 16 years, 6 months. So, though they eloped, my lord, subsequently they voluntarily appeared, my lord, before the police station, my lord. Lordship may peruse page 12, my lord, forwarding report. Page 12, my lord, ground of arrest, number 2nd ground, my lord. So, only the 2 days, 44 days.
How many days?
44 days, my lord. So, my lord, only 19 years of birth.
There in the forwarding Lordship, it is mentioned accused person along with the victim girl
appeared
before police
yes,
on 12/6.
Yes, ma'am.
So voluntarily.
No, I admitted that both are not, it is not kidnapping but elopement. Both are eloped.
So since 12/6, 13/6, they are in the culture.
Yes, 40 my lord. Voluntarily appeared, my lord. There is no question of hampering, tampering or anything. Very simple.
Till now, only
And
365 is there or any other section?
Lordship,
it
not
is
the case day, Lordship, so we cannot say.
yes, my lord, it is a case of Hazo, my lord. Why they have not produced the CD from Hazo police station, my lord? It hardly requires 3 hours, 2 hours, my lord, time. But from the 2 occasions, my lord, that CD has not come. So being that he is also, my lord, though major, but
Your Mr.
M. Hussain.
Heard Mr. M. Hussain, and also heard Mr. Bishop. Mr. Sharma, that in spite of giving several signals to a It is not furnished by him. Mr. Hussain submitted that the voting to the petitioner with him were in love relations, and they out of that they flop, out of which they both of them flop from their house. However, they voluntarily accepted voting on 12/6/2020. However, both of them has appeared reporting on 12/6/2020. And since they there is no question of hampering for them the evidence at this stage, and statement of victim were already recorded as he was voluntarily appeared before the police. Accordingly, Mr. Hussain submitted further custody with for the Mr. Sharma demanded Mr. Sharma recently submitted the district guide that it is a fact that it is a recording report of the accused that both the victim and the accused surrendered themselves before the police station, and considering his period of their custody. It is the case of Hajo.
Hajo, my lord. Hajo, yes, my lord.
It will be Kamrup rural, I think.
Rural.
Kamrup. Okay, will be granted bail 20,000 with 170 to the satisfaction of Planet City of Kamrup rural.
Highly.
19 and 20 lordship CD has not been received. This is commercial quantity lordship.
Issue reminder that
Lordship.
both 19, you are appearing for both 19 and 20.
19. I'm for 19. My
20 I'm appearing for SC Council Acid demand.
We have not received the case diary.
Lordship.
It has to be received. Call for the case diary along with the your petitioners are behind the bar since when?
113 days, Lordship. And he has been arrested on 3/4/24.
Yes, 113.
113. Okay, we are got.
Lordship, let it be on 28 August.
20.
28. 28. 28.
28. 28.
Obliged.
21 also, Lordship, we have not received the case diary. We have received the communication from the IO, Lordship, stating that due to certain unavoidable circumstances, he could not produce the case diary.
May I please, Your Lordship? Case is relating to us.
Not received, Lordship.
Case is related to Cattle Preservation Act, Lordship. We are the drivers and handymen of the vehicle, Lordship. The cattles were legally purchased by the owners of the cattles, and the challans are there, Lordship. I have annexed it. Page number 18 onwards, the challans of the cattle.
So you are in custody since age 7?
Yeah, Lordship. 8/7, Lordship. So, in this case, Lordship, what happened? Our vehicles occasionally, Lordship, hired by other persons, Lordship. That time also the vehicles were hired, and they assured us that these are legally purchased cows, and they have all relevant documents. As we are the drivers and handymen of the vehicles, we are oblivious to do duty, Lordship. We are performing our duties, Lordship. The vehicles as well as, Lordship.
Okay, we are trying to get where from it has to come.
Lordship, in this case, Lordship, another accused, Lordship, the owner of one vehicle, Lordship, he has approached before this honorable court for PS bills, and this honorable court has granted him the interim protection, Lordship, and this case is fixed after 25 days, Lordship. So, in the next date, 20, so 20 August, Lordship. Lordship, if the case.
What are you saying? 20 August?
20 August is Lordship fixed this matter for CD in another case, Lordship. For another
I'm not
accused.
giving you 20 August. It will be too late.
Lordship,
Considering
considering the length
give you a very short day.
considering the length of detention, Lordship, as on that, Lordship, 19 days we are behind the bars, Lordship. And we are just performing our duties, Lordship. Already cattle are recovered, Lordship.
Definitely come in the case diary.
Lord,
We are listing it at 31st of 42. We will list it on 31st.
Lordship, Lordship.
31st of this month only. We are listing.
Lordship, yes, Lordship. Obliged.
List on remand for reminder for.
Yes, may it please the Lordship. My Lord, in this matter, I was arrested on 1/7/2024, and last Friday this matter came up for motion, my Lord. So Lordship was pleased to call for the case diary. Now the allegation is that, my Lord, page 8, Lordship may kindly peruse, my Lord, that I made some distasteful statement in social media, my Lord, which has hurted the sentiments of the people. So, my Lord, section 295A was incorporated, and I was taken behind the bars. I was put to jail, my Lord. Now, first submission is that, my Lord, I have not made any such statement against these three persons which has been alleged by the informant. And secondly, my Lord, to invoke section 295A, one has to hurt the sentiments of religious beliefs of other community. Now, my Lord, here the informant belongs to the Muslim community. I am also a Muslim community, my Lord, follow the Islam. Now, even if, my Lord, assuming I have made some statements against my own people, my Lord, that does not amount to the offense committed under section 295A, my Lord. And it's almost today's 25 days, my Lord. I am in custody, my Lord. So my respectful submission is that, my Lord, perhaps my custody detention, further custody detention is not necessary, my Lord. I am a local person. Lordship may kindly put any stringent condition, I'll follow, my Lord. There are two small children, my Lord. And I have a very good electrical shop, my Lord, that place, my Lord. It's a very flourishing business, my Lord. And this shop has been closed for the last 25 days, my Lord.
Yes, case they received, my Lord. Some of the witnesses, my Lord, stated that these statements, my Lord, hurt their religious sentiment. So those statements, my Lord.
By 295.
Yes,
it is a religious statement of the other Muslims.
Yes.
Yes.
It is the same community.
Yes. Because they are from the same community. Yes. He is in jail since, my Lord, 1/7/2024.
1/7/24. That's so total internet council for big version of the same community with no but sentiments of the community in which he belongs. Harvard submitted that interest is behind the work 1/7/2022 and thus the Iowa National Court of Classification and hence part of the body interest in the investigation. However, it is ready and will be reported by the verdict. Mr. Bott that there are some intermediate expedition, but cannot be denied that both the victim, both the informed as well as the petitioner belong to the same community, and also considering the mission of the expedition means part of the program. will be under, in which satisfaction it has to?
My lord.
Case is pending where?
Karimganj, my lord. He was produced before the page 16. With the satisfaction of my lord, Chief Judicial Magistrate Karimganj, my lord.
Okay.
I'm DP of that.
May it please your lordship. Lordship, this is a 438 bail application. Here the FIR lordship will find on page 14 lordship. May I read that? I have the honor to inform you that yesterday night at about 10 p.m. the accused person, namely MD Jaliluddin, son of such and such Lakhimpur, was tried to physically intercourse of my cousin Pankaj Kolita, alias Pisla. With reference to the subject cited, I have the honor to inform you that a team of excise officials of the Excise Intelligence Bureau, Guwahati, with the assistance of the undersigned, detected a large quantity of the illegal liquor as per the annexure enclosed herewith in the premises of the accused, namely so-and-so, so-and-so. On examination of the incriminating documents found in the premises of the accused persons, further raids were conducted in the following places and detected illegal liquor therein as mentioned below. So-and-so 3 persons' name is mentioned. On preliminary investigation, it appears that the accused persons is involved in the fraudulent manufacturing and bottling of the illegal liquor, leading to endangering human health, besides causing loss to state exchequer. Further, such fraudulent manufacture deceives the consumer as the cheap liquor rebottler resemble as the premium liquor. The said accused persons could not be apprehended as he fled before the arrival of the raiding team. In order to unearth the racket behind such illegal activity, a thorough investigation is required by registering a case under the relevant section of IPC. For example, 120B, 411, 413, 414, 420, 421, 467, etc. This is the FIR, Lordship. Now, Lordship, it is a fact that the petitioner before your Lordship, the Pankaj Kolita, he is the owner of the land where the raid was conducted. But Lordship will kindly turn to page number 20, Lordship. This is a deed of tenancy agreement that was executed long back on 1st March 2021, whereby Lordship that premises in which the raid was conducted, that was let out to one Moinul Ali, and he was running the business of scrap in that particular premises, Lordship. And I have been residing at a totally different place, which is around 20 kilometers away from the place where the raid was conducted. That is, Lordship will find page 25, Annexure 4. That is the certificate issued by the Gaonpura Lordship. I am the resident of village Dolongpar. Totally different place. And there is no question of fleeing away from the place of occurrence because I was not present at that place of occurrence, Lordship. And I was not aware what activities were carried out by the Moinul, because he has taken that place on rent for carrying out the business of scrap.
My lord, case diary received, my lord. My lord, this is not a case of, my lord, transportation of illegal liquor. Here, my lord, manufacturing and production of illegal liquor. And, my lord, thereafter, my lord, they, in fact, my lord, what happened, my lord, in the, my lord, duplicate labeling is also, my lord, they, after, my lord, producing all these illegal liquors, my lord, they, my lord, affixed, my lord, duplicate label in these liquors, my lord. So, my lord, these prima facie, my lord, 2 kind of offences, my lord, committed here. First of all, my lord, these are, my lord, endangered to human life. And next, my lord, also loss of the state exchequer, my lord, without considering regarding the loss of the state exchequer, my lord. But the, my lord, it is very, my lord, from the, my lord, type of business, my lord, going on, it seems that, my lord, those are, my lord, endangered to human life, my lord. And regarding the involvement of the present accused person, my lord, police and, my lord, along with, my lord, excise official recovered huge quantity of these illegal liquors from the, my lord, residents of the present petitioner. Seizure list also available.
some other accused persons also.
That is the not residence, Lordship.
Yes, my lord. I have gone through that agreement.
It was
But regarding in the entire case diary, regarding there is no mention about who is Moinul Haq, and regarding my lord that he is my lord only allowed this Moinul Haq to my lord rent this my lord house, his house, my lord. And Moinul Haq is the my lord actually running this illegal business as per his my lord statement and the document annexed with him. So my lord, in this otherwise my lord, from the case diary it seems that he is my lord involved. But my lord, now he is taking that plea that that house was allowed to one Moinul Haq. So then my lord, let him produce the original my lord copy of the agreement to the IO my lord, and my lord, let him appear record his statement by showing that I am the owner of the house and I am allowing Moinul Haq to run this to my lord, as a tenant in my house my lord. So let him.
Otherwise, entire raid and entire thing is made. They made the
House of the another accused persons also arrested. There are materials.
That is not my residential house, my lord. That is the premises that has been let out to someone. I am residing at Dolongpar.
That is now his ground, my lord. So that is
Lordship.
So let him, my lord, produce all these original documents of the agreement copy before the IO
Lordship.
and record his statement. And thereafter, my lord, again I need the updated case diary. Otherwise, my lord.
That represent petitioner is no way it was that in fact the owner of the dukan was raided and some ticket for people were but he let out the same device to one modular and in that and he took that was executed by him on 1st of March 2021. At present, it is 20 kilometers far from safe demand. However, it will find important Mr. Port submitted this report that from the metric is that it is that the premises from where the illegal also were recovered is the under position of focus for it the present and further that not the transportation was carried out, but manufacturing and for etc. were also carried out from the state. However, Mr. Indicated one term to cope with the iron he also went with regards to the etc. Provided with and I think the present corporate I and yes, updated case diary.
On my lord, 29. My lord,
So you are giving an update.
29, my lord.
29.
29.
So you are provided with interference so that you can appear and
Lordship, I will produce everything before the IO, Lordship.
avoid by all the conditions, appear before the IO within 7 days.
7.
যাবই নহ'লে গৈছে নি না দিলে যাম
Here, considering the NDPS taken by the learned trial court below and presence of witnesses in two occasions, etc., all considering all this condition, your bail petition stands rejected. Here, I have seen that the case is still at the stage of production and the copy. Charge is not yet framed, though he is in custody since last 1 year, 7 months. Considering all these aspects, your petition, this petition is considered and he is allowed.
One thing is the fast bail, there is a direction to complete the trial, ma'am.
Yes, it is direct.
Yes, ma'am.
Preferably within 6 months.
Yes, ma'am. Most of this.
Charge Malad. This Rajori also succeeded, Malad.
Oh, yeah.
43/21.
Oh,
sorry,
Rajori is again succeeded 21.
No, sorry. Case number 14/2024. 14/2024.
14/2024.
2024. Dated 3/04/24.
304?
24.
So here we are extending your interim clearance date. You want 10 days or 15 days?
20 days around your lordship.
20, no, not 20 days. 2 weeks, that is 15 days we are extending. File a petition with an appropriate application for which that will be considered.
Deeply obliged to lordship.
I may agenda madam today only, madam. I have some difficulties today, madam. Any date, madam, you want to communicate?
We are 35.
But I pay for adjournment today only, madam. Only for the today, madam. I have some difficulties today. Any date you want to communicate?
Was it there an interim for you?
Madam?
Was there any
Interim.
CD
receive, madam. CD receive, madam, interim. Any date, madam. Only today, madam. I have some.
Because these weeks most probably lots of matters are being left.
Yes.
Which can, or you can, if you can retain the seat.
Yes.
Any date as
Any date as per your lordship convenience.
No, no.
Oh, yes.
I am to here to do what next,
Yes,
the
yes.
next
My
week
lord,
most probably is full of things.
Yes, and today is
26. 22.
Because
my
second
lord,
is lots of matters are
7th of August. 7th of August.
7th of August.
7th of-
7th of August.
Interim will continue.
Interim will be continued.
Deep down.
7th of August. Interim.
36 and sorry, ma'am, maybe taken as the last item. Just we have received the text from the registry. We have sent to the police also, but whether he is served or not, we are talking with the IO, but he is out of the police station. He is informed after some time.
May I please, lordship?
In both the matters you are appearing. 37 and 42.
37 and 42.
Both the matters.
Both are same, out of same PS case.
No, you are appearing for both.
Both.
So
The petitioner is on interim, lordship.
in which item you are saying?
In 37 interim,
You are in 37 now.
37 on interim. Already appear before the IO and statement also recorded. And lordship may kindly see FIR, page 11. Page 11 is the FIR, informant is Bijoy Pal, and page 14 is the name of the accused. There are two accused in name in the FIR. One is Arif Hussain and another is Inkumoni Bonia. And so far is item number 37, petitioner name is Arif Hussain. He is already on interim and appear before the IO as per direction of the Honorable Court. And next accused, the Inkumoni Bonia, is already granted PRS bail by the Honorable Session Judge Nagaon. I have annexed the order, copy of order in item number 42, lordship.
Item number 37 is pre-arrest.
Pre-arrest.
The petitioner is Arif Hussain.
Arif Hussain. And
He was
Inkumoni
on interim and
interim, and my submission is the second accused person. He is also granted anticipated bail by Session Judge Nagaon. I have annexed.
but where in which
In item number 42,
Inkumoni is not there.
Inkumoni,
That's why I am searching for.
item number 42, page number 30, lordship may find copy of the order of the Session Judge.
No, we are not on that. In item number 42, name of the petitioner is
No, name of the petitioner is Asif, but I want to show the copy of order of Session Judge, whereby Inkumoni Bonua is granted PRS bail by the Honorable Session Judge Nagaon, who is also one of the accused in this case. Page 30.
So now 37.
Yes.
Please.
Page 30, item number 42, page 30 is the copy of order whereby Inkumuni Bonia was granted anticipated bail by additional session judge number 3 Nagaon.
What is your case?
My case. Lordship, what happened, Lordship? One FIR has been lodged by the Bijoypal against the two accused persons, Arif Hussain and Inkumuni Bonia. But so far, my submission is that this FIR is not maintainable. Because of that, before lodging this FIR, they have executed one deed of agreement between the Bijoypal and both the accused person. I have annexed a copy of the agreement. Lordship would find page number 23
Of which item?
of the agreement, of the item number 37.
Page number?
Page number 23, Annexure 2. This is the type copy of the agreement. Agreement is made between Arif Hussain, Inkumuni Bonia and Bijoypal. The contents of the agreement is that the first party being the 1 and 2 are the Vivo company self-promoter serving at Message Automatic Photostat Center, Stadium Market, Nagaon, and they disclose that they take the mobile phone shop, namely Automatic Photostat Center. The value of the mobile is 7,58,000. They promise to return the said amount, that is rupees 7,58,000 within 3 months. Otherwise, if violated the terms and conditions, the first party will face legal consequence. The first party will abide by all the terms and conditions of this agreement. Your Lordship may turn to page 25. This agreement was also notarized by before the notary public and identified by advocate. And my submission is that both the informant and the accused person, whereby they have executed one agreement regarding the stolen of the mobile. Now, after they have already made the payment also, thereafter informant cannot have the right to lodge FIR against same person. Because if any grievance against the accused person, he can go for civil court because he is governed by this agreement. An agreement was executed prior to lodging this FIR. This is my submission.
My lord, two petitioners in both the case, Asif and Arif. Both are brothers.
Both are brothers.
Both are brothers. In item number 37, Arif, he was working in Vivo company. And allegation is that Arif and another person, Inkumuni, they have huge number of handset, mobile handset. When that come into the light, they subsequently entered into their agreement and returned 7,50,000. That is the value of 81 numbers of mobile. So agreement was regarding the return of the money of against 81 number of mobile, which was probably found short, and subsequently, as per the agreement, they have returned. Subsequently, and now regarding Asif, I am again saying this is Arif in AB. Asif is the brother. Arif provided some mobile to his brother. So he is not so much regarding theft. Actually, Asif was not there, but he get some mobile from his brother. But he is in custody since last around 20 days. Now, subsequent to that, agreement was there. They received amount of rupees 7,50,000. Subsequent to that, when they gone by the stock, again 207 numbers of mobile short. So that is now after investigation, IO and the Vivo company, they have given the total value is 29,70,909. That is against the 207 numbers of mobile. And these people, Arif and Rinkumani, they both are involved. They are doing since long time, but because of the stock was not checked by the company, because of that prima facie it was shown that only 81 numbers of mobile. So that amount already returned. But regarding 207 numbers of mobile when found sorted, value is 29,70,909. Then only now that FIR loss. Now, one person income money was granted bail by the lower court only because Malat just you see the order sheet that he has not violated any previous bail condition. Because interim is not violated only because of that. But there are materials, not a huge amount of money. Malat prima facie though there is only regarding 81 numbers of mobile, 207 numbers of mobile they are not and total value is 29 lakh, more than 29 lakh. So Malad, he is one of the main prime issues. And regarding Asif Malad, he stated that my brother gave me mobile. So regarding him, Malad, he is already in 20 days in custody. So 42 maybe he is not directly involved. But regarding item number 37, he is one of the main person accused, and total value is 29 lakh, more than 29 lakh. So and now it is after investigation, police has come to light that a huge amount of money is involved, and these are the total stock when they have done. Total 207 numbers of mobile now still missing. So that has to be custodial intervention is necessary.
But after getting the interim order, he already appeared before the IO. His statement also recorded. And Lordship may kindly see the FIR page 12, paragraph 5, the contents of the FIR. Our soap passes 1,089 numbers of different types of mobile from 1/4/2023 to 6/12/2023 from the Vivo company. Again, Lordship may turn to page 13. They at present in our soap from 1/4/2023 to 6/12/2020, when we calculate the balance of our stock, then we found that 288 numbers of mobile is a great difference. But information also not come with clearance. Lordship may kindly see that same period he mentioned, and within that period he executed already agreement between with the accused person. He also not come with clearance. So when I appear before the IO, and already my statement also recorded, and COEC is also granted by the Honorable Sessions Judge Noga. So I may be same footing, Lordship.
At that point of time, the whole stock was not properly
because
checked.
Both Inkumuni and both are same position. So custodial detention is not required. Already I appear, I not violated any condition.
But when it was granted to the Inkumuni, Malat, regarding these 207 numbers of mobile, that fact was not come to the light.
No, from FIR it still reveals that conduct of the informant is not clear. He not come with clearance because he already executed agreement within the accused person. How can we believe that? If he not executed any agreement within them, then it can be court can understand that he with clean hands. But he himself says they have stolen. He himself executed agreement with them, and after recovery of money, thereafter they resign from the post. Again, say that so and so mobile phone are lost from soap. And Lordship again, one line, page 14, for the sake of convenience. His FIR, para 9. The Sumit Biswas, son of Santosh Biswas, resident of Hoibogao, English Poti, Noga was working as a manager in our institution. I suspect he was involved with the accused person. But his name was not written in the FIR. The conduct of the informant is not.
There may be
he named two persons. Again, he mentioned in the Sumit Biswas manager he was involved, but his name was not in the name of accused.
One person
this
alone,
is my humble submission.
One person alone may not fill this huge amount of mobile. Totally
see that they are
involvement may be there.
They are only sale person. Both person are sale person, but manager is responsible for all the business.
Just I want to ask you, as they have stated that they purchased such kind of mobile handset, and out of that 28 numbers of mobile handset were missing, and regarding 81 or 87 there was an agreement. Initially it was just $2 million, and thereafter they came to know that 207 mobiles are still missing. In that context, is there any document collected by the IO?
Regarding
Really, you cannot say that file was in our
That
company.
all her written complaints are
Missed.
true.
There has to be something. Because already an executed agreement was submitted that the period is same.
Period is same. That's my submission.
Same. So if period is same, then the calculation why it was missed.
Once she take money from recover from them, thereafter again they have
money value is
terminate from job.
7,58,000. That is already reflected in the FIR that value is against 81 numbers.
81 numbers. I am not on that. I'm just asking you is there any document that in their stock such kind of mobile handset was there out of that
and blaming in the name of
simply verbally he cannot say.
She also blaming the manager, but he not made him accused. And all the business all controlled by the manager, not by salesperson, because there are so many persons in the shop. Accountant, manager.
Stolen items number stock is there. List of stock is there. Stock book, stolen items. Yes. Mobile phone. There are list. Total stolen item stock 207. Numbers about this. This is the list. Bill number, price. They have issued some bill also, but they have not deposited the money. They have actually not stole the mobile to other, but that money has not been deposited in some cases. And in some cases, without the receipt, they just stole it. They are receipt money. Stolen item.
Who asked you to enter into an agreement for 81 mobile handsets because at that time stock was with them. So there are some.
Maybe manager also involved in one salesman cannot manage.
One salesman cannot sell a mobile in normal course. Everyone knows it.
May sell, but a huge amount, 288 numbers may not be. The involvement of other person may be there, but after their thoroughly interrogation,
What he said
come into the light.
Sometimes, Lordship,
he appeared
for claiming the insurance, the owner also do that type of offense, Lordship.
Mr. Parasar, whether he reported before the IO?
Yes.
Yes, I have the copy also, received copy of the.
Arif.
On 27 immediately after.
company কাম কৰি আছিলো মোক ক'বলৈ যে মোক ইনকুমনি বনিয়াই ফসাইছে মই এখানে জড়িত নাই so he gave the blame to ইনকুমনি already enlarged on bail so if all will release on bail so ultimately this amount of money totally মোক ইনকুমনি ফসাইছে মই এখানে জড়িত নাই আমি কামৰ পৰা ডিসেম্বৰ মাহতে ওলাই যাওঁ they are
terminated from the job.
Terminated. ওলাই যাওঁ 6 মাহ ধৰি বেলেগ কোম্পানীত কাম কৰি আছো this incident was earlier so he is just simply he is denying মই জড়িত নাই মোক ইনকুমনি ফসাইছে ইনকুমনি already released by the trial court that court below that he is not violating the they have granted bail and they have appeared. So it is what they have done. They are simply doing their duty. Otherwise, they will be violated and again bail will be cancelled. So what mercy they have done? They have just appeared only because they have granted the interim order.
So Lordship, Koig is already granted bail. I am also same footing.
Same footing is now. If all will
and if the contract of
there may be that manager. After thoroughly investigation, their custodial interrogation, that may be come into the light. That manager may be involved in it. Again. Otherwise, regarding only the stock report is there.
By executing agreement with the accused person, how can believe the FIR?
Stolen items stock, my lord.
Sometimes the owner also takes some policy to obtain the insurance, benefit of insurance company. That type of. Because first he take money from those persons.
But here
After he
not taking the benefit, they are directly blaming you only regarding your involvement.
There are list, my lord, model number and all this, brand name all written, and price are also written, 15,000. Stolen items. IO also, my lord, one objection is there. As per the objection of the IO, my lord, Sumit Biswas, the manager, also may involve in the case. That suspicion already written by the IO, my lord. Suspicion is there against the manager also. And the mobile which used by Asif, my lord, who, that invoice is fake. Asif means that item number 42. His brother, he issued an invoice in the name of his brother, but that invoice was fake. So, not guilty of the Arif actually. And he is already in jail since the last 20 days, but regarding him, I have no such objection.
It's okay, but their agreement between for 81 and then again it was a bit. What prevented him to
Lodge FIR earlier.
chalk and stocks if it was there? Suppose if it was missing, because period is same.
period is same, he different person in the FIR.
Within that period only the stocks were there and they were missing.
Also informed and executed agreement with the accused person.
That is him.
And he also blame against the manager, but not in the column, accused column name of the manager.
Now, but
That he may be involved.
no, now I also in his report I stated that Sumit Biswas working as a manager in the business establishment, so suspects that Sumit may also be involved in the case along with the accused. That is suspicion of the IO is there.
Maybe he involved. That is not bar to guard this petitioner.
But one thing is that with the jacket of interim order, that interrogation and without the jacket of interim, that is very much different, my lord. Also,
That is so unadded.
he will just appear, yes, I am appearing, this is only blaming, Inkumuni is the main person, Moi Jorito Nai. This is the person.
Both are salesperson in a particular soap, and as per FI also, they are same.
US board. Submitted that the other patient there was a of 81 numbers of assets, and in terms of that there was an agreement with the informant and the present petitioner along with one Inkumani Poni, whereby they have already returned the cost of the mobile asset of 81 numbers of mobile asset, which amounted to 7,08,000. But after receiving the amount of money, present if the FIR has been lost by the informant with some person concocted delegation of listing of another 207 numbers of mobile handset. However, he appeared obtaining it and reported IO for this report further suggests that the other coactive component authority granted which repeated the dispute by the land and considering the ground of carrying the present petitioner but Mr. Parash that the certificate information is collected by the file and the present file has to be lost by the informant only after coming to know about the missing of another 207 numbers of or another missing of 207 numbers of mobile phones. Cost of it is around 29,77,909. It is a fact that it is a submitted earlier. One agreement was made between the informant and first whereby they returned the cost of 81 numbers of mobile phones for amounting to rupees 7,68,000. But thereafter only it has come to the notice of informant that another 207 numbers of mobile handset were missing. Mr. Parak reported the has to deliver payment honor some other as well as book the other culprits who may be involved in other. The further one Mr. Sumit Biswas, the manager of the company, also may be involved in the alleged offense. And I will and he did in connection with this case. Next one, it is the FIR not get with persons namely and one Inkomani Pora. From the FIR, it's seen that the stop was there to be stopped from 1 and the informant gave to know about the missing of 81 numbers of mobile handset from the shop and then and accordingly one agreement was made between the persons. But from the FI stock period of stock is 1 for same period of stock is same, that is 1 for 6 when the missing of 81 numbers of mobile handset was there. So question arises what written from calculating missing mobile handset from the period of 1 for when the agreement was executed, when the agreement was between them. However, there may be the involvement of some other persons, namely, especially the manager of the company, suspected to be maybe whose involvement may be also suspected. The IO has also collected the stock register, and it was noted that it was used for 7 numbers of motion and that are still missing. The agreement with partners, it was executed prior to filing the FIR, and period of stock of the expedition for interest and hence accordingly I might and that the interim interest did
28/6/24.
28/6/2025 is hereby made applicable. However, the IO is hereby directed to interrogate forward the present accused petitioner as and when their interrogation may be required for the interest further information. Next time of company is 40 Archangel it is subject for the petition is to be documents and it was and since
6/7/24.
6/7/2024 considering this verification payment and Mr. Grant from the address it mobile from his brother that is the boy Mr. Arif and he involved in theft and there is no involvement of the present petitioner in the theft committed in the mobile shop. According to Mr. Russell, submitted that for the check. He is satisfaction of which committee? It is the case of
Noga.
Noga.
PGM Noga. Always.
Time 19.
My lord, here, with due apology, my lord, in fact, in the bail application, we have committed a mistake, my lord. Instead of Hallam, we have mentioned it as Biswanath. That's why probably, my lord, in the order it has been reflected as. Lordship will see the order at page 11 and 12, my lord, page 12. The first para, it will be, my lord, Hallam PS case number 46. And
instead of Biswanath, it should be
Hallam. That is, my lord, there in the bail petition at page, Lordship will find it in the page 26. Bail petition at page 26.
Oh, 26.
The 26 of the bail petition. In the FIR.
Yes.
And one more part, my lord. Here, the petitioner number 2, Lordship status has joined in the T state in September 23. It will be, my lord, January 23. That we have stated in the FIR.
In the month of September, instead of September, it is January.
January. Page 11, it is mentioned. my lord. Page 11. In the 11th line, my lord, the petitioner number 2 was serving in Nirmala Tea Estate since January 2023. In the 11th line, page 11 of the bail petition.
In para number?
Page 11, my lord, it is a continuation of para 9. Page 11 of the, my lord, bail petition. Line number 11, my lord, from top. Petitioner 2 was serving in Nirmala Tea Estate since January 23. And additionally, my lord, the inadvertent error that we have made in the bail petition, instead of Vishwanath, we may be allowed to give a corrected printout of the bail petition, at least the from page 1 to page 15. That, my lord, we may be allowed to correct it, my lord. Page 1 to 15. Wherever it is Vishwanath, it will be corrected as, my lord, Helen.
So not only in the title page, but
In the prayer also it is there. Nowadays, my lord, by filing an IR, that can be prayed for correction. Because now, my lord, it will be scanned and, my lord, again it will be, the corrected part will be, my lord, uploaded. So registry may be directed to accept my corrected copy of the bail petition from page 1 to page 15. So they will upload it, my lord, the corrected one. And as well as, my lord, in the bail, in course record also, it will, the corrected copy will be inserted.
corrected copy will be where?
My lord?
Where it will be inserted?
In the original, my lord, copy of the court, my lord, that will be corrected by the registry. I will provide them the corrected page, they will correct it, my lord.
Or in the bail petition?
Yes. Notarized copy I will provide to them, to the registry.
So now here you are seeking presently
Correction of the, my lord,
of, in fact, the prayer portion.
prayer as well as the cost title, my lord. Cost title, lordship will find that page 2.
No.
No, both, my lord.
In our order, bail order, there was a, so whatever it is based on your part, whatever, it should be Halem.
Yes, so far as the order is concerned, my lord, instead of Vishwanath, it should be Halem. And, my lord, instead of, my lord, petitioners joining the T state in September, it should be January, in the interim order. Additional prayer is that, my lord, in the bail petition also, so that in future the same error does not arise. We may be allowed to correct it also. We have made 2 prayers in the eye.
This I the interlocutory certificate has been filed in connection with AB 185 of 2024 for recording of deputy as well as prayer to the AB number 18458 of 58 2024 to the extent that Vishwanath PS case number 46 2024 should be corrected as LMPS case number 46 of 2024. It is submitted by Mr. While the application outside of the as well as the other part, the inadvertent mentioned that Vishwanath PS case number 46 of 2020 instead of LMPS case number 46 of 2024, which needs correction. Further, it is submitted the bail order also. Case number referred as Viswanath case number instead of LNPS case number 46 of 2020. And apart from that, bail order, date of joining of the petitioner number 2.
Petitioner number 2.
It mentioned as September 2018, and instead of January 2020. Mr. What the petition as well as the order directed accordingly. Further, it is submitted that Mr. Gugul that he may be allowed to find corrected type copy of the present bill. So, from case number 5.1 to case number 15. With the correct author as well as the and the other portion of the petition where the police station is the name of the police station is written as Viswanath is the police station. Mr. Gugul, there is allowed for the file corrected copy of the Further, you did the correction of this one, no?
Minor.
Further, the order that
20-7. Page 11 of the IML.
further the order dated 27.
Page 12, my lord, the case number is there.
Petitioner number date of September 2006, January. The above
Highly obliged. May I please allow? This is called a 438 bail application, madam. And your lordship will kindly come to my lord FIR at page 14, madam. He is not named in the FIR, my lord, in fact. Page 14. So as per allegation of this, my lord, FIR, my lord, one accused, my lord, having mobile number, that is, my lord, mentioned in the FIR itself, my lord, at page 14, my lord. And this, my lord, mobile, my lord, holder, see by using others' PAN card, my lord, able some loan amounts, my lord. So that is not me, my lord. I am reading, my lord. Accused mobile number so and so. Sir, respectful humble praise that on last so and so the above name mobile number holder accused without any knowledge using my PAN card having been taken loan in my name from so and so company on last so and so for an amount of so and so total rupees 36,678. I having checked the PAN card credit score in the bank came to learn that above named mobile number holder accused using my fake documents has taken loan from the company. And it is suspected that the said accused by using fake PAN card, other card owned by different person has taken loans in the name of different persons, my lord. So that is the allegation, my lord, against this, my lord, mobile, my lord, holder. That is, my lord, accused mobile number is so and so, my lord. Then your lordship kindly come to my lord, page 18. That is the type copy, and my lord, the copy of original copy is at page 20. So this is the mobile holder from whom, my lord, this mobile has been seized, my lord. Type copy, your lordship will kindly come to page 18, my lord. So this is seized from the person whose mobile is this, my lord. I, the undersigned, my lord, Annex 3, my lord. I, the undersigned,
of so-and-so OP do hereby seize the below descriptive articles documents on being produced from the possession of one Kohinoor Akhtar Amalo. She is having this mobile number, handset. Wife of so-and-so, district in so-and-so with above reference. The seizure list has been made in present so-and-so, date and time of seizure so-and-so. So description of seizure, one green color mobile handset, 5G being so-and-so, and SIM card, that is the number, my lord. That is what, my lord, reflected in the FI itself, my lord. That is the mobile number she used, my lord. So there is nothing, my lord, against me because, my lord, since I am owning a mobile, my lord, repairing, my lord, center, my lord. So this is the reason why I am suspected, my lord. So in fact, it is in fact, my lord, not against me also. That is this person, my lord, who is handling this mobile phone, my lord. She is using this, my lord, and my lord, taking some, my lord, loans by using some, my lord, ATM cards of somebody else. And in fact, my lord, I am also, my lord, the psychiatric patient, my lord. In fact, that was the reason why I was granted interim protection by this court, my lord. And I have annexed the document, your lordship, kindly come to, my lord, page 10 onwards, my lord. This is first, my lord, SGB Regional Institute of Mental Health, my lord. This is an autonomous body under, my lord, Ministry of Health and Family Welfare. It's a central government aided, my lord, hospital, my lord. That is on 19/9/19, your lordship will see.
What kind of disease you
In fact, my lord,
diagnosed with?
yes, my lord. In fact, I have, my lord, filed my additional affidavit, and there it is, my lord, diagnosed as, my lord, your lordship will, if your lordship kindly have for a moment of my additional affidavit, page 39, my lord. Page 39, ma'am, of my additional affidavit.
Don't have. Anyway, it is not available. So what kind of disease?
That is, my lord, in fact, it is diagnosed, in fact, my lord, the language is, my lord, major depressive disorder.
He is under depression.
That is.
Anyway, we are running shortage of time. I'll by 3 by 3, 5 or 3 10.
My lord?
Any other submission?
No. My lord, in fact, my lord, if your lordship, my lord, have this, my lord, additional affidavit, there are other documents to show that, my lord, there are, my lord, medical history of this petitioner, my lord. Since 2019 itself, my lord, there is the record of treatment, my lord, who is suffering from psychiatric disorder, my lord. So that is what, my lord, the contention of this my additional affidavit, my lord, to show that he is a psychiatric patient, my lord. And in fact, that is, my lord, the statutory provision also to that effect, my lord. If somebody is, my lord, medically, my lord, unsound mind, my lord, what is the procedure to be adopted with this, my lord, accused, my lord. The lordship will kindly have, my lord, this, my lord, 328 of the CRPC, my lord. Your lordship is aware, my lord, procedure in case of accused being lunatic. When a magistrate holding an inquiry has reason to believe that the person against whom the inquiry is being held is of unsound mind and consequently incapable of making his defense, the magistrate shall inquire into the fact of such unsoundness of mind and shall cause such person to be examined by a civil surgeon of the district or such other medical officer as the state government may direct, and thereupon shall examine such surgeon or other officer as a witness and shall reduce the examination to writing. My lord, 1A, my lord. That is, my lord, in fact, my lord, amended provision in 2009 in CRPC. If the civil surgeon finds the accused to be of unsound mind, he shall refer such person to a psychiatrist or clinical psychologist for care, treatment, and prognosis of the condition, and the psychiatrist or clinical psychologist, as the case may be, shall inform the magistrate whether the accused is suffering from unsoundness of mind or mental retardation. Provided that if the accused is aggrieved by the information so and so, then I am reading, my lord, subsection 2, my lord. Pending such examination and inquiry, The magistrate may deal with such person in accordance with the provision of section 330. Then your lordship, kindly for a moment 330, my lord, I am reading.
So
Release
you
of...
have time. Yes, we'll go by the records.
Yes, my lord.
Here, Lordship, in the petition itself, Lordship, the petitioner has shifted all the blame to the Kokinura Akhtara, Lordship. Lordship has already seen. Now, Lordship, in the petition, I have nowhere seen as to what his relationship is with Kokinura Akhtara, Lordship. With this Kohinoor Akhtara, Lordship. Kohinoor Akhtara is the wife of his cousin, Kural Lora. Kokinura Akhtara is the wife of Sirajul Islam. And Sirajul Islam happens to be the cousin of the present petitioner, Lordship. That he has not mentioned in the petition, Lordship. Now he is shifting all the blame to Kokinura Akhtara. Now that apart, Lordship, the amount that is shown in the FIR, it is only a small amount, Lordship. From the investigation carried out so far, it goes to around 30 or 40 lakhs, Lordship. Now what they are doing, Lordship, the modus operandi, just to, in short, Lordship, because it will take the whole day to sum up the accusation against him, Lordship, what he has done, Lordship. He appears to be the mastermind. He is not of unsound mind, Lordship. He is a very clever person. What he has done is, Lordship, availing loan in the name of different persons from different banks. No bank has been left, Lordship. Every bank, Lordship, he has taken loan in the name of different persons, including the informant, Lordship, going into lakhs of rupees, fake ID card, fake Aadhaar card, fake PAN card, account number fake, mobile phone number he has given of every relative, Lordship. From there he takes up the OTP. In fact, a number of arrests has been made, Lordship. Around 5 or 6% has been arrested, Lordship. All the co-accused, Lordship, have one name in common, that is the present petitioner. He is the mastermind. Every co-accused, Lordship. His name is filled up in the case, the Lordship. Everywhere. And Lordship, the case, so far, Lordship, the investigation that has happened, Lordship, one account, Lordship, I will just mention. In that account, Lordship, from 1st December 2020 to 12th December 2022, Lordship, an amount of, Lordship, 13,86,559 rupees was credited, Lordship, in that account, Lordship. That account belongs to one person by the name of Suresh Chandra, Lordship. The account is in the name of Suresh Chandra, who is a fictitious person, Lordship. Nobody by that name exists, Lordship. Now that amount, Lordship, has been credited number of times into his account, Lordship, in the account of the petitioner, Lordship. This is only one instance, Lordship. There are a number of instances, Lordship. In every situation, Lordship, he is the main accused, Lordship. And he has been on interim since last year, Lordship. So, Lordship, at this stage, because without his custodial interrogation, that case will never reach its logical conclusion, Lordship. That apart, Lordship, there are instances of fake stamp and seal of different colleges, Lordship, used in opening accounts. There is a never-ending case, Lordship. There are so many materials, Lordship, I just cannot finish it up, Lordship. If Lordship kindly goes to the case diary, I have flag marked the relevant portion. Lordship will kindly go to the statement as well as the bank accounts. Everything is there, Lordship. He is the prime accused, Lordship. And
My
so
Lord,
far, Lordship, no, I am not finished.
Yes.
And so far, his additional affidavit is concerned, Lordship. He has been given 2 medicine, Lordship. One is mirtazapine, that is for the treatment of depression and anxiety, Lordship. Even I had depression, Lordship. Then, Lordship, clonazepam, that is, Lordship, 0.5 mg. Only 0.5 mg is given to him. That is for panic disorder, Lordship. So, Lordship, that is the problem he has. He is no way lunatic, Lordship. In fact, he is a very shrewd person, Lordship. That is my humble submission, Lordship.
My lord, in fact, my additional affidavit.
Additional affidavit for Akara area.
Okay, I have this copy here, Lordship. You can take it.
Day of Christ.
Even assuming, my lord, this offense, my lord, so far, my lord, accused is somebody else, my lord. So if I go, my lord, by the, my lord, statement of my lord, my learned friend, that, my lord, I am not the, my lord, lunatic, my lord. The additional affidavit, my lord, your lordship will, my lord, if your lordship will, the page 1, page, first page 24, my lord. And this was the basis why I was granted protection, my lord. Page 24, my lord. These are the, my lord, documents, my lord, of LGB Regional Institute of Mental Health by the Psychiatric Department. Page 24 and 25. It starts from 24, my lord. Then page 26, my lord. That is, my lord, please admit patient in male psychiatric ward attendant. So this is the, my lord, in fact, what has happened, my lord, during, my lord, while I was granted interim protection, in another case I was suspected to be involved in other case, my lord. Then I was granted interim protection in that case also. Then I, my lord, appeared before the IO. Then they outright rejected my lord, bail order, and I was brutally assaulted, my lord, inside the police station. Then I, my lord, I was admitted in the GMCH, my lord, because of, my lord, brutally assault, my lord. Then I was admitted to this, my lord. Your lordship will kindly come to page 26. 26 of my additional affidavit, if your lordship has got it, my lord. Because there are documents to show that if I am, my lord, suffering from some psychiatric disorder, my lord. And at this stage, my learned friend cannot just, my lord, explain what is the disease I am suffering from, my lord. That page 26, my lord. That is, please admit in male psychiatric award, my lord, word. That is, my lord, your lordship will find that outpatient department. First, my lord, I was, my lord, admitted as, my lord, OPD, my lord, patient. Then your lordship at page 27, running page, my lord. My lord, below advice admit psychiatric ward with 24/7 constant attendant. So meaning thereby, my lord, whole the week I was advised to, my lord, with some attendant to be in the hospital, my lord. Then I was, my lord, advised to admit. Then, my lord, page 28, I won't read, my lord. If your lordship kindly come to page, this page at serial number 7, my lord. Even the...
We'll continue the hearing on Monday this one.
Yes, ma'am.
If you want to make, because time is...
Yes, yes.
List on Monday, could you do? CDP written.
My lord, interim to continue, ma'am. Yes, I'm deeply obliged.
Item 30 may be taken on Monday, madam.
Item number?
39, madam.
No, not possible. It is a special circumstances I am giving. Monday list is already out, not possible.
My lord, item number 36.
36. My lord, we have not received instruction from whether service complete or not. CD also not received. So,
date may be fixed, my lord.
Report.
Which item it is one?
36. It's POXO 6 regarding service already.
Notice served from the office of the PP.
Already sent to the PS also, but whether they have served to the informant not that is not given, and CD also not received. So,
We can be listed
on 6th. 6th or 7th.
By the time you take the instruction from
Yes, yes, sir. Yes, sir.
6th of August. That is.
Yeah, item number 30, madam. The report has to be called for from the SCB police system, madam. 39, madam. And I am seeking a Zimma of mobile phones and a PAN card and an identity card, madam. On the earlier case, madam, I issued notice to the response number 2, madam, which is not necessary, madam, because, madam, I am seeking the Zimma of some particular documents and the, madam, mobile phones, madam. So the report may be called for from the SCB police system, madam.
We have not done particular.
Kiman item?
39. Custody lagan
From regarding Zimma
mobile phone or PAN card and ID card. Fix it date, madam.
Report may be.
Report may be called for from where?
From SCB, madam. Entry option, madam. Police system.
Report be called from?
SCB PS case का मालूम है?
7th of August.
Sir, 8
8th of August.
SVPS case number 72/23 SVPS.
Regarding Zimma, you know?
It's an anti-corruption bureau, मतलब police से मतलब.
Oh, anti-corruption
Yes, madam.
bureau.
SCBPS.
Anti-corruption bureau.
SCB. 72/23. After a mobile phone, PAN card, and I card, no?
Service and LCR is
It's not required, my lord, because I am seeking the Zimma, my lord.
But you need the LCR or not?
No, my lord, not required, my lord. The report has to be called for from the IO, my lord.
Report to help.
I card, PAN or mobile.
No, my lord.
On 8 of August.
Item number 47, Lordship. Here, POXO case, Lordship, probably notice is served, Lord.
Notice is already served.
Notice served, Lordship. So maybe fix next week any day.
Notice is already served. For February, it's submitted. So, what will she be required to represent by any amicus or not? Not need. No need. Otherwise, we have received the case diary.
Yes.
Already, CD is also received. Retain the CD. Are you you are not?
No, Lord, no intent.
Till the next date of listing, yes, when it will listed.
Tuesday or Wednesday? Tuesday or Wednesday, any day, Lord.
31/7. 31/7.
Outline.